As of March 2022, more than 4.7 crore cases are pending in various courts across India. The Supreme Court alone has over 70,000 pendencies, and 25 high courts across India have around 58 lakh pending cases. The rate of pendency of cases has been rapidly increasing in our courts. The dearth of lawyers, judges, judicial and support staff, insufficient courts, unfilled vacancies, the reasons are many.
As per the government data, the pendency has increased all across and has grown all across the country between 2010 to 2020 at the rate of 2.8% annually. However, between 2019 and 2020, the cases increased by 20% in the high courts and 13% in the subordinate courts. Now, as far as these cases are concerned, majority of the cases, that is 87.6% cases, are pending in the subordinate courts.
We have insufficient number of lawyers, insufficient number of judges. Not only judges, we have insufficient number of lawyers, insufficient number of courts in India. For example, today we have some 6 or 7 judges in family court. So each judge has today on his table some 3,000 cases on average. 3,000 cases a judge to handle? And how is he going to do that?
You see, when you talk of delay, biggest delay is in the trial court. Also in the high courts, Supreme High Court has a big problem of vacancies. But there's a lot of delay in the trial courts because we don't have the judge to population ratio like in better parts of the world. See, a small country like Egypt, which has a population of about 10 crore or so, I think you could check it out, has as many trial court judges as India has. So we have 13 times the population, so you should have, and judges, only appointing judges is not the answer. You need infrastructure, courts, then you need the support staff, everything. So the government has to someday think of giving a reasonable amount, budgeting a reasonable amount for the judiciary.
Our judiciary is overburdened with cases. Law experts say many of these litigations are unnecessary and could have been easily avoided. But the blame for pendency cannot just be pinned on our judicial ecosystem. The poor police investigation that results in a bad charge sheet and a lengthy trial is also one of the main reasons for delays and justice denials.
One of the major aspects that need to be sorted out is that a good number of this litigation can be avoided. For example, the kind of proper investigation in a criminal case. And there is no proper efficient systems in investigation. We are still in 19th century in our investigation processes are concerned. We have not developed anything new skills at all in investigation. We still continue to push the person, abuse them, beat the accused to get the information. Beating the accused is the way information is. No investigation happens. So these kind of processes should stop. There may be scientific investigation that would happen in the case. You see, what happens in the court is, on a botched investigation, your judge cannot convict a person. You take any charge sheet in India, look at the witnesses, read the witness statements, random. You have punch witnesses, identical statements. Eyewitnesses, identical statements. Circumstantial witnesses, identical statement. Had a case where the police in a case of cruelty against a wife had conducted an investigation. They had just cut, paste, copied the entire testimony to every witness, including punch witness. How were you supposed to conduct a trial on the basis of that case? Neither he got justice nor I got justice. You understand? Neither the girl nor the boy got justice. It went on for 8 long years of litigation because of a very botched investigation.
See, in Aryan Khan's case, the High Court ultimately appreciated the point that there is no element of conspiracy, no element of meeting of mind. And on the top of it, the prosecution or the complainant themselves, the Narcotic Bureau said there is no case. So why couldn't the court of first instance, the magistrate court, and the second instance, the sessions court, could not appreciate this point? The lower courts, the officers of the first instance, they just give remand, they grant remand to the prosecution. That's their role. So, just to ameliorate this problem, we need to have more qualified judges, and I suggest that their qualification should be at par with the judges of the High Court. Because after all, they are dealing with the similar cases.
In criminal cases, we have one of the most abysmal conviction ratios in the world, because nobody takes a decision ki, somebody must sift out in criminal cases also that we've been unable to collect any evidence worth the name in this case, so there's no use filing the case in court. But here every case will be taken to court, the trial will go on for 8 years, 10 years, and then everybody knows foregone conclusion that the person will be acquitted because there's no evidence. But nobody in the government will take a decision that yes, they will only withdraw prosecutions on political grounds, not on the merits of the case.
Innumerous adjournments, the multiplicity of proceedings, and vacant chairs are some of the many problems of our courts. Some say merely granting more powers to the Chief Justice is not enough. And others echo the same sentiment and say that granting more funds will also not solve this problem. India needs radical judicial reforms.
Pendency will be there. The problem with us is that for anything we approach the courts. We do not go for alternative dispute resolution system. Even if there are all the judges with full capacity, it is not only the person who has been appointed. You have to give him the infrastructure. You have to give him the paraphernalia. You have to have people who can assist that particular judge. It's not a person who is being appointed. When a judge is appointed, it's not only he. You have to have court masters. You have to have other paralegal staff to assist him.
There are multiplicity of proceedings. There is a divorce case. There is an incompatibility between a husband and wife. And their wife is angry with the husband, or husband is angry with the wife. Husband has treated her with beating and all that. She is so angry with him, she wants to take it against him. She is strong. She feels like she must be. She goes and lodges a complaint under 498A. That's valid argument. Then she makes that story of the 498A and goes and says that she is not providing support to me. She files a domestic violence case. Then he goes to the court seeking divorce. She contests the divorce. She goes to the court, says that I want restitution of conjugal rights. So there is, in no time, you see, in fact, you go to any courts in India, a matrimonial case is a package deal.
Statistics would show that a lot of delays happen at the time of serving the parties. People are not served for years on end. And many times, because of corruption, etc., the reports are, office mein बैठ के लिख देते थे that I went there and I didn't find this person else. It's a very easy solution. You give them all smartphones which cost 3,000-4,000. There's GPS attached to him. He must take a photo of the person on whom he serves. Justice Madan Lokur did develop something on these lines, where they notices everything is sent electronically. The judges have to take stock of the situation. They must not grant an adjournment unless it is absolutely necessary. Now, but what happens is that a judge becomes very unpopular if he does not grant adjournments. We're not here to win a popularity race, but you can imagine a young sub-judge and all, if he becomes very unpopular in a Mufassal town, he finds it difficult. So he has to have support of the senior judges and staff, because then otherwise lawyers will complain against him and all. So, but adjournments are also the bane.
There are 20 judges in India per 10 lakh population. The abysmally low figures show the poor state of the Indian justice delivery system, which makes it extremely difficult for the common man to access justice. This, coupled with the government's role in aggravating the problem, only deepens the judicial crisis.
Another big factor for the delays is the biggest litigant in this country is the state. The government is the biggest litigant in the country. Why can't they settle matters without going to court? There's a section 80 in the CPC which says that before you file a case against the government, you must give it 2 months notice. The purpose of this section is कि अगर government को, if I send Deepak Gupta sends a notice that this is my case, in those 2 months the government would take a decision whether there is some merit in this case or not. Now the actual, I have in my 40 years in the profession never seen a section 80 notice being answered to. They just ignore it. But nobody wants to take a stand. No officer is willing to say yes, the government is wrong. We don't owe you 8 lakhs, but we owe you 3 lakhs. We'll give you 3 lakhs.
In India, for the last 2 years, thanks to COVID, things have got delayed because in the COVID, the courts are only looking at urgent matters. And all earlier matters had been adjourned for some time. Though of late, the courts have started looking at all the old matters. But the fact is that India is a litigious society. And Indians like to litigate a lot. So a lot of litigations get filed in the country. And because the threshold of filing litigation is so low, in just about a couple of hundred of rupees, you can actually file a lawsuit. That's one particular reason why there has been a huge inundation of the legal system with these new disputes and lawsuits and complaints.
Indian jails are confronted with multiple issues, overcrowding being just one of them. Our jails are filled to the brim. Many under trials continue to languish in prisons across India for years without their cases being heard. That apart, politicians and political parties also have a role to play in the mounting number of cases in our courts. Recently, Chief Justice of India Justice N.V. Ramana had said that PILs are being misused by political parties to settle political scores or corporate rivalry.
Settling of the political score, this is basically what the Honorable the Chief Justice of India had said. And I must quote that he had said that no doubt PIL has served a lot of public interest. However, it is sometimes being misused to stall projects or pressurize public authorities. And these days, PIL has become a tool for those who want to settle political scores or corporate rivalry, unquote. See, this is an exception with what the Honorable the Chief Justice of India had said. You can't help it. See, you cannot stop anyone from filing a case. It is for them, and the judges or the courts have become very cautious of the fact that what type of PILs are being filed. And in case they find any such frivolous petition or, for the purposes of corporate rivalry or for settling of political scores, they have come down very heavily on such petitions.
There are 4.83 lakh prisoners in Indian jails. Jails are over the capacity. Bangalore's prison has only 2,700 people they can accommodate. There are close to 4,000 plus people in prison. And 70% of the people in prison are under trial prisoners.
We have heard stories of how doctors are given targets in private hospitals to treat as many patients as possible and reach financial targets in a short span of time. But now, we are told that even some judges are given targets to issue as many judgments as possible.
A judge is given a target, you know that? It is very strange to say that. In fact, I have a number of my youngsters, colleagues, friends who are in judiciary. My student is a judge, my junior is a judge. They come and tell me they have a target, monthly target. So I could use them target, 30 judgments in a month. So what the question here is, if a judge is given 3,000 cases and give 30 judgments in a month, 11 to 12:30 on an average a magistrate spends on call work in metropolitan cities or district courts. 1.5 hours. So by the time it's not 11, by 12:30 he would have done just call work. And 12:30 he starts taking a witness. 2 o'clock he has to look into bail applications. They are urgent. From 3 o'clock to 4 o'clock he completes bail applications. So done. 4 to 5 he has to hear arguments. So if it is sessions court, he has to listen to anticipatory bails. So that will take under half an hour time. For a final argument of a case for a trial, he will get half an hour time. Look at the time schedule which I said. 10:30 to 5:30 he is working without a respite. But the mechanism of the system is such. He has actually contributed to really disposal of a case around 2.5 hours, 3 hours. And what he has done, he has conducted only a fraction of a case. A fraction. When he's going to complete that 30 plus witnesses in the case? One case I'm talking in terms. So we fail to look into these aspects and look at the challenges that we have.
Experts say India must harness the power of artificial intelligence to reduce pending cases. AI judges for low threshold matters, complete digitization of records, and making the judiciary technology savvy can reduce the burden on our courts.
Artificial intelligence is evolving in a big manner so as to go ahead and provide effective, cogent strategies for judiciary. Now, you can use AI not just for purposes of clubbing, for purposes of analyzing, but also for purposes of giving intrinsic insights on how these backlogs can potentially be addressed. And finally, even AI can even be used for purposes of looking at low threshold matters. Let me give you an example. In Estonia, they've come up with the concept of an AI judge, where the algorithm is the judge. For a particular limited threshold of, say, commercial matters below $10,000, the matters ultimately tend to get decided by an AI judge rather than by a human judge. If you're still not satisfied by the AI judge's judgment, you can potentially go ahead and appeal to a human judge. But then this is one particular way how Estonia has gone ahead and tried to reduce the backlog of its cases. India can also potentially do with it. Let me give you an example. For example, all challan matters can routinely be handed over to AI because these are very, very small, insignificant matters, but they do take time of the judge's concern. Similarly, other matters pertaining to traffic violations, pertaining to other small, minor violations, which are consuming the time of the judiciary, if they can be appropriately addressed via these new methodologies of artificial intelligence, machine learning, and automation, they can also go in a long way in terms of ultimately reducing the areas of cases.
See, digitization has a lot of factors and a lot of benefits attached to it. Virtual court is only one part of the digitization work which is being done to the judicial system. For example, let's say there is a case which is pending in the Supreme Court on a criminal aspect, and there are a lot of documents which need to be seen by the Supreme Court, which is before the Sessions Court. So when the court calls for those records, it takes time. Now, had it been, if we have digitized documents, it will not take the Supreme Court much time to go through all the documents because it is already on the grid.
We are still groping in the dark regarding virtual court system is concerned. First of all, tech support, the quality tech support. The second part is that the kind of training regarding articulating in a virtual system. See, we are lawyers. Most of us are used to physical court. If you go to the e-court system in India, good amount of work is being done in trial courts to get into digitized format regarding information is concerned. That's the information system. But the disposal is something which is a serious issue.
Judiciary is the sole protector of citizens, minorities, and the other disadvantaged groups. An independent, robust, and dynamic judiciary is the bedrock of democracy. We have many laws in our country, but in the absence of a vigorous justice delivery mechanism, laws become impotent.
To lessen the workload or the pendency, the court should sit in shifts. And for that, we need more judicial officers. I am a member of the Bombay Lawyers Association. We have made a suggestion to the Chief Justice of India, and he has taken our letter as the PIL, and it will be listed any day. So what we have suggested, permanent secretariat in the High Courts and the Supreme Court. They should keep on tracking who is retiring on which date, and they should take the steps for filling the vacant positions. UPSC would know how many IAS, IPS are required next year. So accordingly, they recruit people. Why can't this happen at the High Court and the Supreme Court level?
Cyber has become an integral component of almost a majority of litigations. For the last many years, I've been talking about the need for India to have dedicated cyber courts. And now, as I see a big tsunami of litigations coming in by the end of COVID-19 in the Indian judicial ecosystem, there will be need for dedicated cyber courts, specifically cybercrime courts, who can only deal in an expedited and expeditious manner these various matters pertaining to cybercrime.
We have a national judicial data grid, which gives every case is today on that grid. Every case in the country is on that grid. This is probably one of the finest anywhere in the world. The World Bank has commended India for this NJDG. But it has become a data bank. It's become a statistical storehouse without that storehouse being used as a management tool. See, that storehouse should be used as a management tool to group cases, to identify the very old cases and everything, and then prioritize the cases.
The world's largest democracy deserves a robust judiciary. While crores of people wait for their cases to be heard, justice is being delayed for many people every day as we speak. Delayed justice is not just denied justice, but injustice.